Good afternoon, everybody. My name is Chris Justice. I am an associate with the Toronto office of Samfiru Tumarkin. And as always, I'm here today to hopefully answer as many questions as you all have, all things relating to employment law. I also like to start off with a few trending topics in the news and kind of go from there. But definitely get your questions in. If you've got questions about something maybe before entering a work relationship, maybe you're going through something in the middle of the working relationship, or perhaps you've been let go and you have some questions relating to that. Whatever it ends up being, do get your questions in. And as I say, I'll do my best to answer as many as I can. But with that said, I'd like to start off just first by talking about this continuing trend of layoffs going on in various sectors. Most recently, there's some been news in the gas and energy sector regarding cutbacks within the Canadian operations of a lot of companies. And so I know, as has been the past recently, a lot of people are continuing to be let go, perhaps as a mass layoff or as more of a one-off, and they're wondering what their rights are. So, for example, if you're an employee who's been part of a mass layoff, is there any difference in terms of the severance that you're owed? If you're just an employee who's let go in a one-off, is there any difference? And the short answer to that is no. If you've been let go, if you've lost your job, if you've been terminated on a without cause basis, you could be entitled to upwards of 2 years of severance. It will depend on a number of factors. For example, you might have signed a contract, which may talk about termination. But assuming there's no contract in place, other factors that the courts will look at will be things like your age at the time you're let go. So if you're somebody who might be in their 50s or 60s, a lot of times these individuals typically get more severance than otherwise. If you've been at a company for a long time, so length of service, that's another factor that courts look at. Typically, you're going to be looking at more severance, as well as the position that you held at the time you were let go. So the more senior of a role you had, generally speaking, the more severance that's owed. But those are the main three factors: age, position, and length of service. And lastly, there, of course, is the issue of when or if and when you're going to find your next job, the availability of similar employment out there. But again, depending on your circumstances, you could be looking at upwards of 2 years, whether you're part of a mass layoff or otherwise. And you definitely don't want to be accepting any kind of a severance package, even if you think it looks good, before first getting some legal advice. So give us a call if you're in those situations, because we do want to make sure that you, of course, get the most fair and deserving severance possible in your situation. There's another story I wanted to talk about, sort of on the opposite of what I just mentioned. There being cutbacks, layoffs. There are some companies who are actually expanding. One company is Lululemon. I know that in Vancouver, their headquarters, they're expanding. There's a number of jobs that are going to be made available in that area. And so for people who are potentially thinking about getting into a new job, whether it's with Lululemon or otherwise, if you've been given a contract, an agreement, an employment agreement, something that your company is asking or this company is asking you to sign before you start work, you are going to want to have that reviewed by a lawyer. You may think that, as long as they're paying you the right amount and you're getting benefits and you're getting vacation and you're getting RRSPs or pension and bonus amounts, that everything is all good. But you don't realize potentially that there are other areas of the contract that you may not know about that will actually have a dramatic effect, potentially on amounts that may be owed to you later on. And one prime example has to do with the termination section. So if you're somebody who's been given a job or offered a job and asked to sign a contract, there likely will be a section in that contract dealing with your rights in the event you are terminated or let go. And usually when you start a job, the last thing that's on your mind is what happens on my way out. But it is very important that you get a lawyer as well to review the contract before you sign it, so that that lawyer can highlight for you various potential issues with the contract. You may not realize it, but if you sign a contract with a very good termination clause in it that's very restricting, you could be later on down the line looking at the difference of tens of thousands, if not more money, that you gave away as a result of signing that contract that may not have happened had you had that contract reviewed as well as potentially negotiated. So, whether you're being let go and you're wondering whether the severance is enough, or you're joining a new company and you're just wanting to make sure that you fully understand the contract you're signing and what the impact is, as I say, depending on what happens in the future, definitely get some legal advice. It's going to help you and probably save you a tremendous amount of money later on down the line. There's also some news here about a number of employers trimming their staff and having people be considered what's known as an independent contractor. You might be in a situation where an employer wants to hire you or has hired you, but not under the title or the label of an employee. And instead, you're being told that you're an independent contractor or a contractor of some sort. Maybe you've got your own business that you're invoicing through, taking care of the HST yourself. But there's this label that, you're apparently going to be an independent contractor. And a lot of people think that if they're an independent contractor, that means they're not entitled to the same rights that an employee is entitled to. And a lot of people actually mistakenly believe they're an independent contractor when they're actually not. They're an employee at law. And it doesn't matter if you have a contract that labels you as an independent contractor. It doesn't matter if you think you're an independent contractor. It doesn't matter if your employer thinks you're an independent contractor. It's ultimately going to be the law that decides what you are classified as. And it's very important because if you are an independent contractor and you're let go, you're not going to be entitled to the same type of a severance package that an employee would. However, the good news is that it's very rarely the case that someone is considered an independent contractor, even when it's said very clearly in a contract. So if you're somebody who's maybe entering a situation like this, where you're being labeled as such, or maybe you're already thinking you're an independent contractor and you're wondering about your rights, you're wondering about whether or not you are in fact or in law a contractor or not, again, you want to give us a call because these situations are not black and white. There's a lot of factors that need to be looked at, but the long and short is that most people, if they're let go, are going to be owed severance regardless of what their company calls them or labels them, and even regardless of what they themselves might see themselves as or consider them to be. With that said, I'll get into some of the questions and I'll go back to some topics that I wanted to touch on as well, if we've got time for that. I wanted to start with Kathy McKenzie on Facebook, who is saying that they have worked at a parent company for 16 years. And now this company is transferring the entire department to a sister company, some sort of, I guess, affiliated company, assuming it's within the same sort of industry, similar works being done there. This person, Kathy, is saying that the company, however, is not being transparent about what is going to change, and no details have been given whatsoever. And Kathy's wondering what are their rights in a situation like this. So it's a good question. I think, Kathy, and in general, it's always good to have as much clarity for there to be as much transparency as possible. And of course, before you are asked to move anywhere or transfer to a different department or have the terms of your employment potentially changed, you're going to want to ask your employer the full details of what's going on. Because until you know what the changes are, you're not going to be able to tell whether or not it's a big change or more of a minor change. There are some changes that can be made within the workplace that are completely above board and on side. And then there's other changes that are so significant that to force them on somebody could result essentially into a termination. And then therefore that employee who's in that predicament will have the opportunity to either accept those changes that are big or tell the employer that they're not agreeable to those changes, that those changes represent too much of a departure from what they had been doing, and that therefore they're not agreeable. And then at that point, the employer can either decide to reinstate you back to your previous role or may end up terminating you. But you're going to want to be able to communicate very clearly whether you accept or reject the changes. And of course, in order to do that, you're going to have to know what exactly they are. So Kathy, if I were you, I would ask the company for essentially a breakdown of those changes. But I would also suggest that you give us a call because once you do have a good idea of those changes, or maybe they will never even give you a good idea, but you're going to want to be careful when it comes to your communication with that employer. You just want to make sure that you're not saying anything that could be potentially harmful down the road. But the first and foremost thing is to get an understanding of what the changes are so that you can properly assess just exactly how your job is going to change. Because that, as I say, that'll give you an idea of what your options can be. And also, when you talk to a lawyer, the lawyer is going to better be able to advise whether you have the ability to kind of hold firm and, stand your ground, or whether the employer somehow has some leeway in terms of changing the terms of your employment. And then the other thing too to remember when it comes to companies changing someone's employment, in most cases, if it's a big change, they're not able to do that. But if you've got a contract that speaks to changes being made or talks about the ability of the company to make certain changes, that could also determine how much leeway that employer has to make the changes. But as I say, you need clarity, because if the changes are big and they're being forced on you, that is known in law as a constructive dismissal. And you, again, would have the ability to go after that company or that employer for severance as though you had been let go. And for having been there for 16 years, your severance entitlements could exceed 20 months. So it's not a small potential amount of money, and you would have options in that case. But I would say get in touch with us if you can get some more information from the employer, or if you're having issues getting that information. Sometimes, unfortunately, it takes an employment lawyer getting involved to get the company to either see the light of the day, see the light, so to speak, or at least just give clarity on the changes themselves. But I appreciate the question, Kathy. I know a lot of people in that situation kind of wondering the same thing. I've got another question in from Cindy on YouTube, who's saying that their union isn't representing them properly, and whether or not there are any lawyers who would help in the situation. So, Cindy, what I can say is that, well, number one, I don't specialize in unionized work. We at this firm primarily focus on non-unionized matters. And I have encountered this question many times before, where people have had issues with the way in which their union is representing them. As far as I understand, you have an ability to present a duty of fair representation claim, or at least pursue a duty of fair representation claim in that context. The main argument being that your union is not representing you properly, but it will ultimately come down to the unionized context, the rules surrounding that, which again is not my expertise, and also how the union is representing you. So it'll depend on how poorly the representation is. But what I can also say is, from a statistical point of view, as far as I'm aware, those who try and essentially cast their union to the side and have a different lawyer help out, those situations are very slim. The chance of success in a duty of fair representation claim, as far as I understand, is very low. Not necessarily the best news or the news you may want to hear, but it is seemingly very hard to have your union sort of pushed to the side and have a different lawyer step in. You, as I understand, again, would have to file that duty of fair representation claim and go from there. Cindy, what I would suggest at the very least is to either look to your collective bargaining agreement, because that oftentimes holds the answers to a lot of questions, like such as what steps can be taken if my union isn't representing me in the way that I want, and as well talk with your local union rep, because I'm sure they're going to have the information should there be an issue with them in terms of the next steps to follow before you can get even into a situation where someone like me would be able to help out. I've got another question in from Yanks on YouTube, who is asking whether or not there's anything that can be done if you've been let go during a probationary period. And yes, there potentially can be things done if you've been let go. A lot of people incorrectly assume that if they're let go during a probationary period, that automatically means that they're not entitled to any severance. And there may even be language along those lines in a contract that's been signed. But one thing to know is that contracts aren't always the be all and end all. And even if there is something in the contract, that doesn't mean that it actually would be enforced by a court. And secondly, it could also depend on how long this so-called probationary period is. and whether or not there's anything even in a contract that talks about a probationary period. Because if the contract itself is silent on the probationary period and mentions nothing about it, and you've been at a company for a couple months, you could still potentially be looking at several months of severance, even though you've only been there for several months. Or there's other situations where probationary periods get extended beyond 3 months, beyond 6 months, and then the company tries to let you go just because you were technically on this so-called probationary period, when, again, even with someone with 6 months, 7 months, 8 months of seniority, can be looking at several months of severance. So if you're somebody who's on or has been told they're on a probationary period and you've been let go, definitely don't assume that you're not entitled to anything. Your entitlements could be relatively big, depending on, again, your age and the position you held and what happens after you lose that job. But yeah, it is a very important question because there are a lot of misunderstandings around that. So thanks for that question, Yanks. I've got another question from Alexander on YouTube, who is saying that they work for a temporary agency. They had an injury outside of the workplace, and they asked their employer for accommodation in the form of reduced work hours. Apparently, Alexander was told that everything would work out, that the company was willing to do that. And it's, I guess, been since April. They still have not heard from either of the employers or the temp agency, and no ROE has been issued. So Alexander, or anyone for that matter, if you are in a situation where you have suffered an injury, whether it's in the workplace or outside the workplace, and you need accommodation, generally speaking, your employer has a positive obligation, a duty to accommodate your injury. And if you are able to provide that employer with medical documents, with a note from your doctor or a treatment provider of yours that recommends a reduction in hours, for example, let's say you're working 40 hours a week and now your doctor is recommending 30 hours. Generally, you submit that medical note or that information to your employer. You let them know what the accommodations are. You ask that employer for that accommodation. And as I say, in most circumstances, your employer is going to have to accommodate that. And if they don't accommodate that, or they just simply refuse to speak to you after you were assured that they would accommodate you, then your employer has arguably breached their duty to accommodate. And that could both result in a termination, which could allow you the ability to essentially leave that situation and receive severance as though you were let go. And or as well, possible extra damages or compensation for the fact that there was a failure to accommodate. There would arguably be a discrimination issue at play with respect to disability. And a lot of employers, while they may not want to accommodate somebody, while they may think that the accommodation is unfair or overly burdensome or an inconvenience, that simply is not going to be enough to justify them in not accommodating. There has to be evidence of undue hardship, which is a very high bar to meet for employers to refuse to accommodate. And in most cases, that's just simply not the case. Alexander, it seems like you've been essentially ghosted by the employer, by the temp agency. And as you say, there's been no ROE issued. I assume that you have not been working essentially since April. So there are some major issues going on in your particular case, and I do highly suggest you give us a call. We can set up a consultation. We can kind of go through all these issues about what the communications have been, what information you've forwarded to your employer or the temp agency as well, and just exactly how best to sort of address that going forward. Maybe you want to keep your job and we can work on getting a hold of the employer and working something out there. Or you may, as I say, have an option to essentially leave that situation and go after the severance as though you were let go. But thank you for your question, Alexander. I've got another one from Cindy on YouTube who's saying that they've been simultaneously harassed at work for years. Their union knows about it, but is not taking any action. And if there's anyone that can help a unionized worker. And Cindy, this is sort of a follow-up from Cindy's earlier statement, which has to do with getting a lawyer to help out where the union drops the ball. And again, you would have to, as I understand, file a duty of fair representation claim and go from there. But yeah, it could be a difficult road to go down, but I would start at least with that and see where that takes you. I've got a question from Sam on YouTube who's asking whether or not, or the question, I guess, is how do you know if you're an employee and not a contractor if that's what the employer is telling you? And so this is a follow-up to the opening topic I addressed, where a lot of times, far too often, people are being told they're one thing, but the law considers them something else. And I guess the long and short of it, Sam, would be the more control the employer has over you, that's going to be one major factor in determining whether you're an employee or an independent contractor. So normally an independent contractor, a true independent contractor, is going to have the freedom to do whatever they want. Maybe they can hire subcontractors. Maybe they can set their own hours, set their own wages, set their own responsibilities and duties for the day. But if you're somebody who is having your hours set by the employer, you're somebody who's having your salary or your wages set by your employer's telling you what to do on a daily or weekly or monthly basis. Your employer is subjecting you to performance reviews. You're having to check in with people at that employer. These are all examples or forms of control that your employer would have over you, which is not customary as if you're to be considered an independent contractor. Another factor that the courts look at when sort of deciding independent contractor or employee is how much time are you actually investing in this employer? Is this the only employer you work for? Or are you a contractor who works for 20 different companies at the same time? If this is an employer that's the only employer you work for, and this is where all of your money is being made or most of your money is being made, then you're, of course, going to be very much more dependent on that employer. And that is another main factor in determining if you're an employee or not. So as I said before, you could have your own business. You could be invoicing them. You could be paying HST yourself. You could have a contract that says you're an independent contractor. All of that can be true at the same time, and still you're not considered an independent contractor. So exclusivity, control, sometimes you may have an email with that company's name on it. Maybe if you're talking to customers, you're presenting yourself to them as being connected to this particular company and not, your own independent business, let's say. So again, just examples of things that I look out for when trying to determine what's what. But these cases can also be quite contentious. Employers will try to take a hardline position, push back. So it's not the easiest to negotiate with them. But as I said before, if you're in a situation like that, you give us a call, we schedule a consultation, and we go through in finer detail all the ways in which a court would probably deem you to be an employee, or at the very least a dependent contractor, which, in that case, even then you're still owed severance. And it is, again, very rare, for companies to successfully prove that somebody's an independent contractor as much as they may want to. And it's huge, because an independent contractor could technically get nothing on their way out, and an employee could get as much as 2 years, like I was saying. So there is a lot at stake there. But it is and can be quite nuanced. And so definitely give us a call. And at the very least, just so you know, going forward, should this ever come up, sort of how to best prepare or understand the situation. I've got another question in from JR on YouTube asking what the best thought process is at explaining an intra-internal department transfer. I'm not entirely clear what you mean by that, JR. I think, in terms of any internal department transfer, again, if you're in a position where you're being transferred to another department within the company, that could on its own be a significant change and justify you in receiving severance as though you were let go. If an employer, for example, is looking at trying to explain an internal department transfer, they technically could have a number of different thought processes. A lot of times there are reorganizations, there are restructuring that takes place in companies. Maybe there's a new manager or new management come in. They have different ideas on how they want the company to be set up. And so there are still technically ways, may not be the best approach, but there are ways that someone can be transferred to another department and not have it be technically offside or illegal. But there are also a lot of situations where that happens where employers can't do that. The thought process behind explaining the transfer, I think could be relevant if you believe that maybe the transfer is being done in bad faith or that you're being targeted in some way where others aren't. But if it's more of a general overall organizational thing where it's happening to everyone, not just yourself, then it could very well be a legitimate sort of process or transfer that's taking place. But it just comes down to how big the change is. Companies can make big changes to your employment, and that can be in good faith, and still it can be considered a constructive dismissal. So it's not to say that a company has to have bad faith motivations when making changes to your employment. They can be motivated by good faith, but they can still be considered a termination. You can still have rights. I've got a question in from Bev Elliott on YouTube, who's asking whether the employment laws have changed since 2021. And Bev is asking why I think it's long-term care workers are not receiving severance for being placed on unpaid leave for vax refusal. And generally speaking, even though we are in 2023, the law is still unsettled. It is not settled whatsoever when it comes to whether or not those who are placed on an unpaid leave for non-compliance with vaccine policies, there's still no clear-cut answer to whether or not they're owed severance. There are a few decisions that have come out, unfortunately, that have gone against employees. But that's also not to say that if you are someone who's lost their job for refusing to be vaccinated, that you have no case. There absolutely is still a chance that these cases or these people are owed severance. It's just that the law is still continuing to develop. And so I suspect we will get more clarity on that issue this year, or at least I hope to. But right now, as I say, it's very unsettled. Which means that if you are in a situation like this, you should still give us a call because there is an ability to settle these cases. I've settled cases involving people on unpaid leave or involving termination for vaccine refusal, and I've been able to get them severance. Is it going to be 100 cents on the dollar? Not right now, given the state of the law, but it doesn't mean that you aren't without options. So that's as much as I can say now, but I would just otherwise say stay tuned because, as I said, there should be some updates in the law coming this year, and it'll definitely be interesting to see where the courts ultimately land or decide on that. I've got another question in from ND who's asking whether anything can be done where an employment agency is concerned. So not the actual company that the person may be working for, but the agency through which maybe that person is being paid. So someone is working as a temp agent, for example. What should a person hired by an agency know? So if you're somebody who's been hired by a temp agency, and let's say you have one client that is a bank, it's arguable that your employer is both the temp agency and the bank. I had a situation come across not too long ago across my desk about someone who was hired and is paid by a temp agency, but their only client is a bank. And they wondered whether or not the severance that they're owed, they should be going after the bank, the one that they're actually communicating with on a daily basis in terms of what they're doing, or if it should be the temp agency who's the one paying them, the one sending them checks. And as I say, in either situation, you could actually go after either or. You may have more options. Just because you're being paid by an employment agency doesn't mean that you can't necessarily go after somebody else, especially if it's your only client and you're effectively working at some other place day to day. So that someone in that situation should know that it's not necessarily the agency that is the only one you can go after when it comes to that. But these things can be complicated. So it just depends on what is actually happening in the situation. If it's termination, you could potentially go after both or one of the two. If there's other changes going on in the workplace, it just may depend on what changes exactly. I'll take one more question. Thank you everyone for getting them in. I've got a limited time and I will definitely answer as many when I get back, but I'll take one more question from Elizabeth on Facebook, who's asking whether a reduction in salary would be considered a constructive dismissal. And the answer to that is it depends. It depends for the most part on how big of a reduction it is. But anytime your salary is reduced without your consent, I definitely suggest you should be calling us, getting some legal advice, because in most cases that would be a constructive dismissal. Even if it's a change of only 10% or greater, that is often enough for a constructive dismissal and would allow you the ability to essentially say no to the change, which then puts the ball in the company's court, whether they want to stand firm with their position or reinstate you back to your previous salary. But again, when it comes to these changes and communications with your employer, I definitely recommend you give us a call so we can kind of take you through and guide you through that process step by step so that you're saying what needs to be said without saying anything that might be potentially used against you later on. That's my time, guys, today. As I said before, I very much thank you for all the questions. If you do have any further questions, please keep them on hold. We do this Q&A all the time, so get your questions in at the next possible opportunity. Thanks again. You'll see down below there, as far as any disability law questions are concerned, you can join Martin tomorrow, June 13th, 10 o'clock Pacific time. But thanks again, everyone. I'm signing off, and do definitely enjoy the rest of your day. Thanks again. Bye for now.